Hello, everybody. This is a broadcast on uh, CF Digital, and the today's program is titled "The Challenges to Child Reunification Programs." And I think first I want to introduce our guests and but briefly explain the purpose of this. The challenges to child reunification programs is really the means with which the courts are kind of taking a step back, listening to different sources of information and misinformation with respect to how we intervene when it's found that children may be brainwashed, and extremely so where children may seem to show an unrealistic and unfounded and sudden detachment from one, if not both, of their parents. But it's typically when a child is in a custodial parent's home and in family court being heard for remedies and remediations. So today, ladies and gentlemen, our guests are Joshi. He's an attorney, of illustrious attorney based in Michigan, but providing services internationally, and is renowned for his litigation experience. He is editor-in-chief for the American Bar Association's litigation magazine. He has served on the board of directors for the National Association of Criminal Defense Lawyers based in Washington, D.C., and has provided counsel to families and judges and policymakers across the United States and internationally in the UK, Canada, Luxembourg, Hong Kong, British Virgin Islands, and China. His focus lies at the intersection of forensic sciences, human rights, and complex disputes in situations involving severe parental alienation and psychological mistreatment of children, including false allegations of child abuse and recovery of abducted children. Now, that's a mouthful, but importantly, it's a very complex matter when families dissolve. I'm going to briefly interrupt myself because my wife's niece just gave birth yesterday to her first child, a daughter. Thank you. Yeah, it's been a very long pregnancy, a very long that and a long labor period, over 2 days. So there was a great concern. But the beginning of a family. And Judge Philip Marcus, who was going to join us from Jerusalem, had an important event, his son's engagement, and there was a surprise party for his son in Jerusalem, and so he is focused on family. And we look at this whole matter and all of the CF Digital and Contemporary Family Magazine and all the work that you do, we all do. It's really to restore family, restore the value of family and the relationships, the vital relationships that science and research have shown to be vital for a child's success in life. Let me continue with our illustrious and very important panel. Brian Hart. Brian Hart is a therapist and parent coach from Massachusetts. He is a custody consultant and has served on the board of the Parental Alienation Study Group organization. His work addresses disorganized attachment and developmental trauma, childhood adversity and disrupted parenting, parental separation, personality disorders, and child treatment. And that experience is really critical to this conversation. I want to continue with the introduction to Brian Ludmer, attorney Brian Ludmer from Toronto, Canada. Brian has come from personal experience of divorce and alienation, and succeeded in restoring the important relationships and loving relationships with his children, and has worked for many years now in helping families internationally as well in this field, and speaks internationally to attorneys and judges, as well as consulting on very challenging cases. Brian is a keynote speaker at many events across North America, and has also been a source of important material for CLE webinars that my agency will be doing more of because of that subject. I want to introduce Phil Hendricks. Philip Hendricks is also a therapist and the principal of Covenant Counselors in Colorado. He serves primarily as an advocate for children and parents who desire to be with them. And if you think of that concept, the desire to be with one's children, it's critical, right? Those that want to remain involved in their children's lives when parents come apart, but also to find the ways of healing, of giving strength and emotional health to those impacted when there's unwilling partners or traumatic events accompanying the separation and divorce experienced by more than 40% of families today compared to the marriage rate. I want now to first create a context of child reunification programs. That is a choice that the courts make, and some courts, not all courts, and that has been a viable choice that so many have had experience with over the last 15 to 20 years internationally. And I think if we understand that child reunification programs, intensive immersion programs that separate the children from one parent to be deprogrammed, if you would, and find the connection, the attachment that is natural and healthy with the other parent who had been excluded, demeaned, and distanced in every conceivable way, then we understand that that really impacts maybe 30% of the 30% of parents who divorce and separate experience a high conflict. And it's not the first choice. There's a gradation of options that judges choose. And I think our audience may identify with many of these choices. When you look at the issues of judges in making determinations, they frequently depend upon outside material, outside testimony from experts, licensed clinicians, who, by the way, may or may not have had any exposure or any understanding to child needs when there seems to be a presence of disenfranchisement by the child. And that continuum initially is examined by the judge with some cookie cutter recommendations in many courts around the world, particularly Western countries. And that is, you look at maybe therapy, if there's obstruction or unwillingness to participate in child custody agreements, visitation agreements, then there might be need for supervised visitation. Supervised visitation is where there's a third party that helps facilitate time sharing. Time that a child has with another parent that can be observed and documented so that the courts can then, through the reporting, have a sense of what the quality of that visitation was like, and how that has transcended over a period of time. That has helped for the court to make further decisions about custody. With respect to visitation, there's also therapeutic supervised visitation, where the need for a more intensive facilitator that is a licensed therapist becomes more valuable. But when there's obstruction and difficulties and lack of progress, you will also find judges needing to consider, if they haven't dismissed the case, then they will look at other options. And I'd like to invite Brian Hart, who I had the pleasure not only of knowing for nearly 7 years since we met, giving testimony at the State House in the state of Connecticut legislature, but also speaking with Brian an hour before our program, who reminded me that there is a continuum of treatment that we really need to look at. And Brian, I want to thank you so much for that call, as brief as it was. But I want you now to please share that with others, because I think that further contextualizes what we are going to further discuss and need to understand, because of the misinformation, because of the challenges too, and because of the research which demonstrates the positive effect of more extreme choices judges may make. Brian, please, thank you. And I want everyone, by the way, rules of order. There's no order. I want everyone, as they may like, please share. This is a conversation, and I appreciate your patience with me in opening up today's program with these statements from myself. Thank you.
Thank you so much, Mark. And it's so diligent and smart of you to have both two mental health professionals and two esteemed legal professionals in today's panel. And you're right when you talk about the research. There's over 1,000 research articles that are supportive of the theory of parental alienation, and they outnumber the number of psychological articles that might be detracting from parental alienation. That's about a 10-to-1 ratio, so that the science clearly supports the theory of parental alienation. And when it comes specifically to the 4-day reunification programs that you just mentioned, there's at least 12 articles that are specific to that. And oftentimes the people that detract from those 4-day programs do not look at the research, or maybe they're not even aware of it because they're not very scientific or research oriented. And so you mentioned also the continuum, Mark, and thank you for mentioning that, because if it's very mild alienation, in other words, the child still has some level of contact with the targeted or rejected parent, they could go for weekly therapy, 1 hour a week, maybe 2 hours a week. The court could allocate that even at a mild level of alienation, where the therapist has complete discretion with the court's support of how that treatment plan will go, which members of the family will attend with the child, okay? But when it reaches a moderate or a severe level of alienation, that type of weekly therapy is contraindicated, which is a medical term, which means do not do, okay? And, there are so few therapists, or I'm a mental health counselor or a social worker or PhDs that have the subspecialty experience with parental alienation to be able to succeed at any level, including that mild level of those weekly sessions. Even the most experienced person could not succeed at a moderate or severe level with hourly therapy once a week. And that's where these 4-day reunification programs do a wonderful job. We've got articles from Richard Warshak, 2 of those. We've got Turning Point for Families has a great article that was written, and as well as Kathleen Ray in Canada, and 96% success rate. And the reports from the clinicians that are executing these 4-day reunification programs, which include a 90 days is the typical of suspended contact with the alienating parent that was found to be abusive by the court, with the evidence of the court, those programs have a 96% success rate, and that's despite the efforts of the alienators who try to thwart these programs from happening. And sometimes there are detractors that even involve the media and exploit the children, and there's coercion with the children to try to reject these programs. So typically in these 4-day programs, it's within a day and a half that the previously indoctrinated child against the parent will be hugging the targeted parent. Does not take long to be able to help these children. And the last comment that I'll make, and this especially will be echoed by, I think, my legal peers here, and that is that there are false allegations of domestic violence. There are false allegations of child abuse, and there's also false allegations of parental alienation. So, we really need to be diligent and understand that all people that claim parental alienation are not actually victims of it, and they're trying to manipulate the system. And I think that's where all sides of this, if we say there's parental alienation advocates and there's domestic violence advocates, we all need to be sensitive to. Our advocacy has to make sure that we're not advocating for a client that is manipulating the system and is not a victim of domestic violence, or their children are not victims of domestic abuse or child abuse, and that we don't want people that are accused of being alienators that aren't. And that's where the 5-factor model published by Bill Burnett and others plays a role. So thank you, Mark, for putting this together. And I won't be able to stay on the whole call, but I'll look forward to enjoying the views of my colleagues. Thank you.
Thank you so much, Brian. One of the things, and Philip, I'd like you to weigh in also to what Brian had said, if you would, and with your experience. However, one of the things that I think from the complaints that I have read that have been, in fact, promoted in ProPublica, for instance, widely read public online magazine, which generally has more sensibility. But many of those complaints are really coming from custodial parents who feel threatened, who cannot allow the other parent the opportunity to share in the affection of their child. And I think that relates to their own not only experience and perception within their own marriage or relationship, but also their own childhood trauma. And what are they reliving? And why is their anger so heated? And why do not they, at the time that a child may be ordered to have this immersion 4-day program, why should not the custodial parent also be remanded to individual therapy and counseling and help in coping? And I don't know if that, in fact, is part of the order at the time that a child may be so ordered into the 4-day therapy. And Philip, please, if you would, if you'd like to comment, that you're most welcome, of course.
Well, it's tough to follow Brian Hard. He's a walking encyclopedia. So, yes, let me provide a minor correction, Mark. I think almost exclusively the people behind these efforts, denial efforts, are not just aggrieved parents, but they, in our parlance, they are the alienating parent. They're the ones behind most of this chaos. And this is in part done to provide cover for themselves and a distraction from what they have done to the situation and their negative impact upon the child. I think that's pretty clear from who is driving this effort. The programs themselves, as Brian illustrated, are very successful, very effective when allowed to proceed as intended. Most oftentimes, when there are problems, the problem is because of the, as you said, the custodial residential parent who attempts to contact the child and often does have back channel communication with them, thereby disrupting the process. That non-communication is an essential part of the process itself, because the child needs to be able to rely on emotionally from the formerly targeted parent. And that tie needs to be temporarily disconnected from the custodial parent in order for the process to be effective. There are any number of other reasons why programs can be unsuccessful, but those numbers are extraordinarily small. As the success rate for these is in the high 90% for almost all of the programs. So there's very little valid criticism of them, other than those that are spouting, as we call them, PA deniers. They're spouting their version of reality despite all the scientific evidence to the contrary.
How you used a term, an expression, with respect to the ties that a custodial parent had, and if I'm speaking incorrectly, please correct me. But essentially, when a child is taken from the custodial parent, there needs to be a process, and I just presume that there may be, for prepping the child and prepping that parent, the custodial or residential parent, to participate in that process and to be as supportive as possible, certainly at least informed as to what the expectation would be. But how would the court, do you think, best explain to all parties, not the need for, but the how to understand that 4-day separation, that 4-day departure from a more familiar household, a relationship with that custodial parent?
Well, that disconnect needs to occur. It must occur in order for the child to thereby become attached to the targeted parent, the person whom they formerly rejected. And without that, the program will likely fail. And as I alluded to moments ago, that in those rare situations when a program is not successful, that's almost always the reason why, is because there's been back channel communication. But let's not underemphasize the need for the residential parent, the alienating parent, to engage in a therapeutic process of their own. That's just as essential. We put all the focus seemingly on the targeted parent and the child.
Yes.
And we often neglect, as family systems demands, we neglect the alienating parent who is the instigator behind all the chaos. So until and unless a court or other authority enforces their own orders and requires the alienating parent to engage in that therapeutic process, the process will not be as effective. That person had not changed their ways, so to speak, because the child will then, when they are reintroduced, hopefully in a supervised setting, they're going to continue their old patterns. So there needs to be a change in those patterns. needs to be a change in their parental behaviors towards that child in order for the program to be successful long term.
That brings up a number of questions, and I would like to invite the public to know, our listeners to know, that this is a fundamental and overview of challenges, not simply to the matter of a 4-day immersion and what sadly has been brutally called a camp in the media, but it's a program of healing.
And I remind you, Mark, there are intensive programs for other maladies and situations as well, namely substance abuse, drugs and alcohol. We call those intensive programs, generally starting with a residential program where they do 30, 60, even 90 days. And then they go to an intensive outpatient program. Why can we not use the same methodology and structure with these kinds of scenarios?
That's a fabulous point, because the nature of maladies within society require a similar approach, though content is addressed for that individual, pathology or problem. But we need to accept, what is helpful to all parties, that process. And Philip, thank you so much. Can I invite our attorneys to comment on what they would like to share with respect to a number of these important points that Brian and Philip, have introduced for all of us, please?
Well, Ashish, why don't I start with the case that you and I are involved in together? Okay. So even the most dire of situations can be turned around. My mom has a great expression: where there's life, there's hope. Sometimes it takes the eve of trial capitulation by the alienating parent who knows that they have been found out and a trial is not going to go well, to get them on board with solutions. And so then the question becomes, if I can't trust you because you're capitulating now only on the eve of trial, and I want something that will be resilient and successful over time, what does that look like? So that's a settlement, if you will, or an interim settlement that has ongoing court oversight, has a series of stipulations that put an end to the narrative that the estranged parent is the cause of the family dysfunction, assert that this must be solved because it's dire if it's not, appoint an interventionist because it's not really therapy, it's a psychoeducational, very directive sort of process where there's accountability.
That's right.
The patient, if you will, is the entire family system, with the interventionist being responsible to the court to produce a result, which means it's distinctly not therapy. And in this case, as in many, there was an individual therapist for the child who crossed all kinds of boundaries, created harm, created dysfunction, manipulated the child, drank the Kool-Aid in that sense, colluded with the favored parent. So we know what the solutions look like. If we add the knowledge of why conventional therapeutic interventions fail, because usually you get an interim court order that says, get out of my courtroom, you guys should be solving this instead of litigating it, go do some therapy. and there's no further guidance, no structure, no accountability,
Right.
no oversight.
Yeah.
Those are 99.9% empirically and logically going to fail. And each successive intervention that fails to meet its goals actually makes solving it harder the next time. The worst case I had, and I only got involved near the end, there were 10 separate different therapeutic interventions, psychiatrists, psychologists, psychotherapists, social workers, then around the bend again, and nobody seemed to learn the greater fool's theory. So there is a way to do this short of a trial. And I'm pretty sure I spoke about this at one of the earlier PASG conferences, either Washington or Philadelphia. But it's highly structured because of the risk of failure if it's not, because we would prefer a solution that doesn't involve a temporary protective separation. They have their own challenges despite the substantial record of success. So that's part of my pitch for how to help these families. They need an intervention. It's not therapy. It's highly structured. And if you can't get it, or if you try that, what I call the one last chance, and it doesn't work, then you're left with what the Canadian courts call the, there's 4 choices. You're picking the least objectionable of a series of choices. It's a stark dilemma is what some of the cases refer to it. And all you're left with at that point is, are you going to do this sort of temporary protective separation with all its bells and whistles? And it doesn't have to be a formal program. It can be led by a local systemic family therapist who understands how this works. Or you're just going to say goodbye because it is an aspirational statement to say that, oh, well, I'm sure the children will reconnect with their mother or father in future. There's no evidence of that. It's not a good strategy, etc. So I'll turn it over to Ashish.
Ashish, hold your thought just a second. And if I may, I just want to rephrase something that Brian had said, as I understood, and that this program is not therapy. Brian, did I hear you say that, if I may?
Yeah, therapy is generally founded on the therapeutic alliance, and a therapeutic alliance would be fatal in these directive sort of processes.
More specifically, it's not psychotherapeutic. It is psychoeducational.
So that is a very important distinction. And I wonder if, the court may know that or has explained that. And Ashish, given your experience, how might you? And I know you're collaborating with Brian, and it's not the first time that you've been engaging with Brian. You're very important people in leading litigants and counsel in this field. But I want to return your follow-up comments, if I may, and also address that issue, how you would tell the court, how you explain to the court that argument of interventions not succeeding. This is an opportunity, and probably the last straw for some families.
Thank you, Mark. First of all, it's a pleasure to be here with all of you. What I would say is it's all dependent upon facts. We have to focus on the facts. Many, many times I have come onto a case to realize that lawyers, judges, therapists, they all meant to do the right thing and meant well, but they have made a case far worse. we ask questions about what is the scientific underpinning of the intensive programs? Where is the research? Is it peer reviewed? What's the data look like? Who wrote the reviews and all of those?
Right.
None of those questions are asked ever when a judge simply orders a kid to therapy. When there is a visitation violation, for example, or where the kid says, I don't want to go and see mom or dad because of whatever reason, and quote unquote therapy is put in place. No one questions the efficacy or scientific underpinning of that therapy. What exactly is the therapist supposed to treat? And more often than not, if the case indeed involves the alienation dynamic, the traditional therapy setting makes it far worse. It ends up over empowering the child and disempowering the parent. And it just keeps on going on. They get more toxic. They get more loyalty binding exacerbated. And the judges continue to get frustrated by asking questions about why isn't the situation changing? We have been in therapy for X number of months or years, and what's going on here? So it's important in this case is to have some findings of fact made as soon as possible. Because if it involves alienation, you need a particular kind of intervention. And by the same token, if it does not involve alienation, but it has other issues such as significantly deficient parenting, neglect on the part of a parent, abuse on the part of the parent, or a bunch of other reasons which make sense as to why a child is resisting a relationship, we need those findings as well. Because mental health intervention is supposed to treat a particular dynamic that's at play. And unless we know that in advance, we are simply trying to speculate. So as much as people don't like litigation and they want to stay away from it and they want to settle the cases, in many cases, it is important to go to court and get some findings made. Are the allegations true? Does the allegation of alienation have merit? Does the allegation of abuse have any merit? What indeed took place that has been causing the child to reject a parent or resist contact with a parent? And once those findings are made, then we go to the next step of intervention and what is appropriate. It's a night and a day difference when a clinician gets a finding from the court. For example, the parents agree that either the court understands and agrees that both parents are safe, but the child has been rejecting the mother without justification, and the father has influenced the child to reject the mother by engaging in some alienating behaviors. Now, that kind of a finding gives a particular kind of information to a clinician who is going to provide intervention versus a judicial finding such as the mother has demonstrated significant issues related to alcohol abuse or substance abuse. The mother has engaged in significantly deficient behaviors of parenting. The mother has caused the child some sort of trauma or some sort of issues here, which has led the child to reject the mother. That information allows the clinician to provide a different kind of intervention. So we need to dig down on the facts and get some findings in the record as early as possible before we move down to interventions.
Ashish, I think everyone, absolutely agrees that the need to find facts as early as possible will create the greatest opportunity for selecting the most immediately appropriate intervention. And in many of the cases that I have been invited to either testify at as a professional witness or to otherwise observe, because as Philip, my agency provides family therapy and supervised visitation and therapeutic visitation. So many cases, that approach which is so sound and sensible, does not appear to have existed. If there's argument over the assignment of therapeutic type of remedy, which is late in a case, that shows deficiency. And it shows also that children are harmed because of that delayed intervention or the delayed attempt to recognize what facts are. And we know in litigation, we have, the right and the wrong. We have the did not. We have the he said, she said, so to speak. And how would you and fellow attorneys, Brian, suggest that courts dig more rapidly into the fact finding as opposed to the argumentation from a litigation process?
All right. Well, I'm sure that Ashish will agree that all the courts everywhere are overburdened, massive backlogs, can't get timely dates. Since COVID, because of all of that, there's all these rules. Your affidavit cannot exceed on a 1 hour motion in many Canadian provinces, say 12 double-spaced pages. How are you going to prove the primary causal factor in a family dysfunction and refute the other side's narrative? Because remember, they got a narrative in 12 double-spaced pages and a 5 double-spaced page reply on a 1 hour motion. It's impossible. So then you have to be dealing with the court to get a half-day motion or a full-day motion, and then they tell you that those dates are being given out 6 to 8 months hence. So in an ideal world, there would be some sort of fact-finding to assist the intervention and spearhead the sorts of supports and changes of behaviors. But the court system today doesn't allow for that. So what we're having to do is say, with the right stipulations, the right buy-in by both parents, that whatever the causality is, we're not prejudging it, but here are the rules of the game. We're supporting 2 parent-child extended family relationships. Each parent makes a vote of confidence in the other parent. Everybody commits to follow what the therapist says with a view to the healthy solution. Everybody buys in on what the healthy solution looks like. Maybe there's an existing parenting plan that isn't being followed. Everybody agrees that the goal of the intervention is to restore the family. So there's no blame game. It's just a future-focused sort of everybody buy into it so that we can just let the therapist get on with fixing it. And the mistakes everybody has made, mistakes of omission, mistakes of commission, misattributions, misrepresentations, misunderstandings, it'll all be worked out. Why? Because we all have a common vision. There's a parenting plan we're going to support. We all agree it's essential. We all agree it's urgent. We all agree to do whatever's required to get there. So does the past really matter other than in an informative sense of, here are the topics on which we struggled in the past. We need to do better, everybody, including the children, on those topics. The therapist will help us craft a go-forward parenting constitution, behavioral expectations, and we won't debate the past. It's not about fault-finding. It's simply about, can we be informed by our past difficulties and get right into, without the blame game, right into solutions about the future on the assumption that everybody could do better, including the children could do better. And so in the best of all possible worlds, the therapist would be informed to some measure, because when you get in and try and fix it, you always learn more than what can be learned in a courtroom. But if we obviously could pull the two historical narratives closer together through some fact finding, it would be ideal. I don't think anywhere we have the court system, resources, timeliness, focus and attention that we need, have needed, need even more today. And so this is what we have to do in the absence of that, because to send every family to trial to figure it out sounds great, but it'll take you 2 to 3 years to get there, by which time there may be nothing left to save. So that's the situation we find ourselves in today because of the limitations. There's every judge who ultimately does a trial in this world says, this system needs to separate these families out of the mix earlier and devote special attention to them and actively manage them. All the trial decisions say that. I'm picking up the pieces here 4 years on. We need to do better at an earlier stage. And you do have court decisions that will make, say, a finding of PA mixed in with something else on an interim motion. So they do exist. There is authority for that. But it's a lot harder today to do. There's usually an inclination to send the family to trial, and they absolutely need attention as soon as possible. So, Ashish, is the U.S. court situation as overburdened and subject to all these limitations as we see in Canada?
It depends. I've found that to be especially true in larger metropolitan areas such as San Francisco, Detroit, Chicago, where the family courts are simply not just overwhelmed with the amount of cases on the docket, but also with the fact that a significant proportion of litigants are pro se. They're representing themselves. They can't afford lawyers or don't have lawyers. And that creates a problem of its own. And I absolutely agree with you that in an ideal world, it would be great if you could get a trial or an evidentiary hearing. But when it doesn't happen, I have found that judges who hold review hearings, or who at least put dates on the horizon that we don't have time now, but we are going to get to a trial in 9 months from now. And in the meantime, I want parties to follow family systems therapy or counseling, or some mechanism is put in place with future accountability. Those cases do better than lawyers or some coming up with some sort of a system on its own and having no oversight by the judge. The other problem I often see is therapists being at odds with each other. There's a reunification therapist agreed on by everyone, but then the child has an individual therapist against the reunification therapist.
Right.
So then the child's therapist continues to have individual sessions with the child, and the child appears to have some distorted belief system. And the child's therapist keeps on telling everyone the child is simply not ready. We can't proceed with reunification until the kid is ready for the reunification, and we lose precious time in that. So these are some of the issues that we need to confront early on and try to get ahead of. And if everyone is pulling in the right direction, that's great. Even if the progress is slow, if direction is right, it's still a progress.
I have been smiling during Brian's discussion, much of his latter part of the discussion about looking. I've been smiling with you too, Rajesh, but Brian is talking about looking to the future. And my father, may he rest in peace, for many of my adult years, if not earlier, would remind me, don't look backwards. Life doesn't go that way. And my father was a product of the Depression, product of anti-Semitism, product of World War II. had great, first generation. So there are a lot of negatives that he had to deal with. But he said, screw it. We're looking forward. We're moving forward. And I think both of you have been couching the realities of not only caseload, but what is practical procedure. And perhaps it might be that this period of COVID and post-COVID is giving us the important fluidity, if you will, that Ashish, you have just been saying. If the need for trial remains present and can be scheduled, though down the road, meantime, there must be efforts to provide some measured therapeutic assistance during that period. And would that have been a philosophy at the time of my own divorce in 1997, 98? It would have been, I think, a far better result than I'm fighting laryngitis. It's like a laryngitis, esophagitis. But it would have been a far better result. And I think that there is a lot of really important nuggets here. Philip, before I continued, I had another point to make. Did you want to jump in on what Brian and Ashish had just shared with us?
Well, I was nodding throughout both of their talks because I'm in agreement. Courts are overburdened in some jurisdictions here in Colorado. Up to 90% are self-represented parties.
Wow.
The process necessarily takes longer, if you will, because of that. But further, I think there's the overwhelming lack of understanding of these issues within our courts, with notable exceptions among attorneys, and sadly, even in the mental health profession, and which points to the need that we have for better education about these issues, not just family dynamics, not just the issues of parental alienation, coercive control, and the many other things that are often involved in these kinds of scenarios, but there's a general lack of understanding of both legal and psychodynamics involved in families. And let's face it, families are different. And each individual family has its own peculiarities, and you cannot replicate that. And for courts to attempt to apply cookie cutter resolutions to that inevitably will lead to disaster for those families.
That's really key. That's really key. The issues of court, and I think that's certainly another topic that I would like to address with you all down the road, that of the need for court reform, which is court reflection, understanding court process, and understanding who is leading the courts. The matter of judges being reassigned even during a case. This is horrific. We talk about the importance of consistency for children to have access to parents. How about the consistency necessary when someone is adjudicating a case and is comfortable, is more knowledgeable, and then is moved to a different type of court? We're going to be concluding shortly, but I have found this discussion to be so important and meaningful, and particularly one point I did want to mention. And I know Ashish, you have to leave shortly also, but when Brian, you had said that rather than the 4-day on-site program. It might be that a local therapist to the family, local to the family, needing this type of assistance may find more expedient and more ready, resource. And then that in itself opens up the challenges. Who is credible? Who has the least bias? Who is most open to hearing and understanding and refuting and discerning and assisting? Because the bottom line is what Brian had said, and Ashish as well. We need to be goal oriented. We need to be focused on what the value to the family will be, to the child. And we must make that effort to do that. And so that means selecting the appropriate authority, the appropriate therapist who might be asked to conduct such an intervention as a 4-day program. Then that will be really significant. And a process for the courts to better understand. I'm going to invite final comments now. I'm so grateful for all of you, of course, to be here and share this important insight on the challenges to child reunification programs and what has led into that, what has really magnified issues that are critical and yet oppositional to the realities of these success rates of exceeding 90% and higher. Gentlemen, your final comments would be most welcome, please.
Okay, so I'll just offer one quick thing, which is there are resources. There's collections of case law that I've done where it has judicial commentary on why the conventional therapeutic intervention failed. And they're really interesting, those reflections after the fact, where judges said, well, it's obvious why it failed because this, that, this. And so if you collect a series of those cases and you start to see the patterns, well, then that's what to avoid by building in a covenant pattern to prevent that behavior. Again, sins of commission, sins of omission in your intervention. And then the other tool that we have these days is we have a whole bunch of kids who have reconnected with a lost parent. Again, no science behind how frequently that happens and just an aspirational sort of thing, but sometimes it does happen. And when you listen to those kids, young adults, about how they lost the relationship, what they were being told, how they were misled, and how they eventually overcome it. Very, very instructive then to look at those sorts of parental and sometimes extended family behaviors and build in a prohibition early on in the post-separation period against that sort of behavior. So we have an experiential data set that goes beyond just the science of studying formal programs, which is what the studies do in order to get a sufficient body of participants. But the really good systemic therapists who have seen reunification happen, the case law where courts make new go-forward orders after the reunification therapy period and recognizes that sometimes where needed, these protective separation periods, they do work. So the review judgments reflect on the fact that things have improved markedly. So we have all these other touch points. They're objective. They can be assembled and be part of the education process for everybody, but also for use in court.
I want to contact you, Brian, with respect to making that available, that information available to others and how they can obtain it. Ashish, did you have another word that you may want to share before we now leave?
I agree with Brian, and I wholeheartedly second that suggestion about looking at case law. I also think it's important to look at professional or peer-reviewed literature when we are talking about these intervention programs and not be distracted by publications such as ProPublica or other social media distractions because they have taken one little kernel of truth somewhere and blown it out of proportion. For example, when the court orders an intensive program or a separation, it does typically do so after a trial or an evidentiary hearings. And it's important to go and look into transcripts, the testimony, what convinced this judge to order that separation. And these social media articles or journalistic articles don't really do justice to those decisions. And it all creates a hype and some sort of a scandalized version that looks very attractive to people on social media.
I agree. It's unfortunately a sensational matter that gives fodder to publication. Sadly, Philip, did you have a comment, perhaps?
Despite the ongoing, continuing need for us to engage those who attempt to deny what has been scientifically proven over many decades of research and clinical practice, we need to fight misinformation. We need to fight disinformation. Legal, mental health profession, and family advocates alike, I think, need to think outside the box to come up with better ways to deal with these kinds of issues. But if we collectively would look at the facts, as Ashish likes to say, and look at the research that Brian has alluded to, I think the answers are there for us. And these programs, whether they be remote or local or 4-day or whatever duration, they are highly effective and can serve families well. We just have to engage in them. We have to utilize them. And in order to do that, I think we need to do a better job in educating the courts and others who are involved in these scenarios that we can better rely on to use the tools that are available to us currently.
Thank you so much, Philip. 25 years ago, when I got involved with the Children's Rights Council in Washington, which advocated for joint custody nationally, it was David Levy who said, providing information, education, and support. That was the mantra. I believe in that. I tried to do this with all of my efforts. And I know there was a recent conference in Connecticut addressing the how-tos. Thank you all so very much for your wisdom and generous time to discuss these attacks on and challenges on these programs. But I want to thank you for all that you do to improve child outcomes when parents separate in all aspects of your work and your advocacy. And I want to wish you all well, and I look forward to continuing conversations and being an outlet to assist you in your words.
Thanks, Mark.
Very much. Hello, everyone. This is Dr. Mark Roseman. I'm founder of Preserving Family Ties Media, an educational multimedia company, which I began in 2020. Some of you may know of our flagship publication, Contemporary Family. It's an online quarterly news and research publication focused on family systems and change through divorce and separation and child custody, and especially looking at the impact of parental alienation and associated behaviors. You may also know of MarkDavidRoseman.com, MDR and Associates, our national virtual support groups, and coaching for targeted parents. All of this is the culmination of my social science research, teaching, and presentations, which you may find helpful in my book, Preserving Family Ties, the same name as Preserving Family Ties Media. We all hurt. We all have different approaches, and we have different vocabulary and different expectations, certainly as professionals. And yet we are all unified by our own individual history as targeted parent, as a professional working with clients to improve family ties when parents separate. And I worked in this field since 1998, gotten to know a number of the really outstanding professionals, leaders in the field of dealing with these changes in shared parenting. And for you, just know that everything that you do to educate yourself is information that you can also bring to those in power to make changes. So ask yourself, how can we accomplish that? Is it such a big task? And the answer is, it appears to be, but it doesn't need to be so. Because number one, you are here and you are being attentive. And if you are open and attentive, you will have the tools and the skills to help others in their own journey and to help the professionals seeking to make those changes. So let's find our own way of navigating this haunting tragedy for many in the family court system, and let's work towards our own personal healing. Please read more about my work in the field of contemporary family and the virtual support groups by visiting contemporaryfamilymagazine.com. Thanks so much, and I wish you all the best in your journey.